Majority rule. What is majority rule, or the rule established in Foss versus Harbottle 1843? It says, in matters of internal administration, the will of majority should prevail over the will of minority. This is known as majority rule. In general, the courts will not interfere at the instance of shareholders regarding management of company if directors are acting within powers given by articles. If the directors or the majority it is acting within the powers of the article, then the court will not interfere in the management of the company, okay, at the instance of the shareholders. It is based on assumption that the majority provides the capital to company, okay, and it bears the risk involved in investment, so the majority should be given wide powers of control. This was the assumption for this rule. What is this case law, Foss versus Harbottle 1843? What are the facts of the case? The facts are, there were two shareholders, Foss and Turton. They were the plaintiff. They took the legal action against five directors and others. These five directors and others, they were the defendants, and the company was Victoria Park Company. What was the allegation made by this plaintiff, by Foss and Turton? The allegation was that the property of company is being misapplied and wasted by fraudulent and illegal transaction, and mortgages are improperly given over company's property, okay. So these plaintiffs sought an appointment of a receiver and action against the defendants for loss to the company, but court rejected their petition. The court said that the sole right to bring action is of company, okay. Company should itself bring the action, not its members. The injury charge the injury charge is not exclusive to plaintiffs, it is injury to whole company. The company should sue in its own name and its corporate character, not individual members. In law, corporation and aggregate of members are not the same thing, okay. If there is an aggregation of member or group of members, it doesn't mean corporation, okay. Both are different thing. What is the rule established? The rule established is that the rule established through this case was that the court will not ordinarily intervene in matter in which the company is competent to settle itself, or in case of irregularity which can be ratified or condoned by its own procedure. So this was the rule established in Foss versus Harbottle. And the logic or rationale given for this rule was that on becoming member, the shareholders agrees to submit to the will of majority, the will expressed in general meeting and in accordance with law articles and memorandum, okay. When any person becomes a member of a company, he agrees to submit to the will of the majority, okay. What are the exceptions to this rule, in which case the will of majority will not prevail over the will of minority, okay, or the court will interfere? What are these exceptions? This rule applies only to cases where company is competent to ratify the acts. If there are any acts which can be ratified, only in that case this rule will apply. There are certain acts in which no majority can ratify or approve, okay. Even a single member can sue in these cases in which the majority cannot ratify. Thus, even a single member can sue for enforcement of obligation owed to company. The member can do so in representative capacity of company, so the relief will go to the company. What are these acts in which the will of majority will not prevail over the will of minority, or the tribunal will interfere? These acts are ultra vires act, okay. The acts which are outside the ambit of memorandum of association, which are outside the scope of memorandum of association, okay, or the act which is fraud on minority, okay. Majority does fraud on minority to give majority advantage which minority will be deprived of, and this fraud has not been done for the benefit of company, okay. This act was not done for the benefit of company. And in what case this rule will not apply? The acts which require special resolution Generally, ordinary resolution are required for decision on internal matters, but there are certain acts which can be done only by passing special resolution. And if majority do any such act without passing special resolution, in that case, the will of majority will not prevail. Okay, the court will take action. Or if there is infringement of individual membership rights of shareholders, okay, in that case this rule will not apply. What are these individual membership rights? That, like the right to transfer share, this is an individual membership right. A person is free to transfer his shares, okay, but the rule applies only to corporate membership right, okay, the membership right which are corporate, okay. Like, what are these types of right? Like the right to receive dividends. In this case, the will of majority will prevail, but in case of individual membership rights, the will of majority will not prevail. Or if the wrongdoers are in control, it means if the majority do some wrong action, okay, illegal act, though the action should have been brought by the company itself, but the control of company is in the hands of wrongdoers themselves. In that case, the court will intervene, because as the control of the company is in the hands of wrongdoers themselves, they will not take action against themselves. Or if there is oppression and mismanagement, okay, the affairs are being done which are prejudicial or detrimental to the company, okay, or are oppressive to minority shareholders, in that case the court will intervene. So this was majority rule, or the rule in Foss versus Harbottle. Okay, if you want the PDF of these notes for revision purposes, you can get the download link from the description box or the comment box. If you are interested, you can get it from there. Next topic will be oppression and mismanagement, which we will cover in next video.